All right. So this is explanation for the March 31st, 2021 contempt purge hearing. If you saw the last video, um, that was the first hearing, and the actor, the fake judge, said that I was found in contempt, and then he made his contract offer. However, at the very beginning, I made stated what my status was and what I was there for. Um, procedurally, what was going on. So go check out that video first before we get into this one because they go in order. So that's the December 14th hearing, and then this was the next hearing. Prior to this hearing, I filed an affidavit of notice and demand. I told them they committed due process violations, and I filed a special appearance, and here we are.
You are now joining the meeting. Hello? Hello, can anyone hear me? I can.
I can as well.
Hey, and who do I have on the phone? Kimberly Hector.
This is full confinement with the Assistant Attorney General representing the Division of Child Support Services.
I'm the accused. By the way, when the AG introduced himself, he also said, I'm here for representing the Attorney General for Child Support Services. He's not representing the mom, not representing the child, he's representing the state. That's their interest. It's in the state and the state's money. Oh, and then I responded when they asked who was on the line. First thing I said was, I'm the accused. That's who I am in my paperwork. I'm not their obligor. I'm not petitioner. I'm not their all caps name. I'm none of that. I have the right to determine and declare my status, and I keep it consistent in my paperwork and in my oral hearings. I am who I declare myself to be, and I declare myself to be the accused, not the title that they give me.
Okay. Mr. Quintero? Is that?
I'm the accused, allegedly, David Quintero. Allegedly.
Okay, thank you.
You're welcome.
Okay. Yeah, I'm gonna go ahead and call the case, and then I know there's some issues we need to talk about. So go ahead, go on the record. This is case SP 2017
Subject matter.
0042. Present on the phone is the petitioner and the respondent, as well as the state attorney general.
They claim.
All right. So I see we have this is the time set for review hearing, but I see that a motion to continue was filed.
That's right. I filed a motion to continue because I was in the middle of a lawsuit against the fake judge in the previous hearing. So in the previous hearing, the December 14th hearing, I actually filed a lawsuit against that judge, that fake judge. That fake judge is not on, these proceedings. This is another fake judge, and I filed a motion to continue, stating that I wanted to concentrate my efforts on that lawsuit, not in dealing with this matter that has nothing to do with me. And procedurally, when you file a motion to continue, procedurally that goes first, which is why that was addressed first before they got into everything else. However, there's no rules here when they just do whatever they want to do. You'll see. Yeah.
I'm going to first ask our attorney general to give me a brief update, and then we'll talk about the motion that was filed, okay?
She had no need or reason to ask him for anything, right? That's because it's the AG that's filing the lawsuit, which is what a contempt hearing is. It's a lawsuit. They file a lawsuit to get the money that they're not getting. So they want to hear from him because they're the moving party in a lawsuit to try to get money for their state debt. That's why she wants to talk to him first, even though procedurally, first I put in that motion to continue. Um, and so they should always go with whoever is moving the court. Whoever's moving the court always goes first. Now they're going with him because of the lawsuit, but I put in the motion to continue. So I don't know. I guess she talks to him. It could have gone either way. So this isn't entirely out of procedure because they're the moving party for their debt. I'm the moving party for the motion to continue. Um, I filed it and it needed a response. There was no response yet. So I guess procedurally, we're still kind of okay just for this particular moment right now and what's occurring right now.
Thank you, Your Honor. Since our last hearing, we have received payments through unemployment benefits, but we have not received any wage withholding payments.
Okay.
Oh, he went into his
And what was the date of the last hearing?
Their debt. That's what they went into.
December 14th, Your Honor.
December 14th here, okay.
So they disregarded the motion I put in first. So yes, it is incorrect. They addressed the motion first.
Sorry, we're having some technology issues.
No, you're having some procedural
Getting access
issues.
to the file today.
Right.
All right. Okay, I've got that one up. All right, and petitioner, you filed a motion to continue?
For the record, I reserve all my rights. I am present by special appearance in propria persona as the accused. And there was a motion to continue that was filed, and the process of service was satisfied as there was a affidavit of certificate of service that was filed proving that service was satisfied of said motion to continue.
She said petitioner, right? I didn't answer as petitioner. First thing I said was I declared my status and I reserved my rights. I reserved my rights and then I declared my status. Okay?
Right. And what is the basis for your request for continuance?
It's listed in the document. I'm not here
Do you
to
have
argue.
anything to add?
It's very specific. This matter is tainted, and it should have been dismissed a long time ago. So I require a written response on the record, and I shall take a continuance until I receive a written response on the record or by acquiescence without a response.
I'm not there to argue. Okay? She asked me about my paperwork. I'm not there to read the paperwork. If you have questions, read the paperwork. Okay? I'm not there to argue. Okay? It's in my document. Look at my paperwork. And, there's due process violations. This matter's over. That's it. That's all I'm there for. Just resolution.
Okay.
Oh, and as far as how acquiescence, they all understood what I was talking about. I moved the court, and if they don't respond, then that is, you basically get what you asked for by acquiescence. Basically, if you don't rebut, you must rebut everything. That's why we always say rebut everything. You always rebut, because if not, then you default. So I told him, I'm having a motion to continue. If you fail to respond, then I'm having it by acquiescence. I'm not asking them. I am telling them. Okay, that's what you need to do. You need to tell them what to do.
Do either of the parties object to the continuance?
Yes.
I object to the continuance. All right, and I want to hear from both of you. So, respondent, go ahead. This original, I object because this original child support order was not established under the Title IV. Mr. Quintero was the petitioner in this whole matter.
She's just repeating herself so much shit.
Of litigation in this matter, and he has several times tried to get the child support order dismissed. And when all of those failed, now he is going on to this new route of his constitutional rights being violated, where originally for 4 years no rights were violated. Mr. Quintero wanted the courts to decide his custody in this child support matter for him, in which they did, and he was unhappy with it. And so now here we are with him trying to still continue to get out of paying his child support. He has never made any voluntary payments, and they've all been intercepted payments from the child support office because he had made it clear in our original custody case and everything that he had no intention of paying child support for this child. He does have another
They asked her
child
about the
fully
continuance.
and had no problem paying child support for. So I object because this matter has been heard for 4 years, Your Honor. It needs to just come to an end so we can move forward.
All she needed to say was the last sentence. And that was it.
And I believe I heard our Assistant Attorney General.
Yes, Your Honor. The state would also object. Mr. Quintero was declared a vexatious litigant in
Irrelevant.
2018. That declaration still remains. So the motion to continue has not come through the proper channels, being approved prior to submission to the court. Also, the basis of the motion is basically that Mr. Quintero has filed a lawsuit against Judge Ferland and therefore seeks to recuse Judge Ferland.
Hearsay.
And to stay this matter until that lawsuit is resolved. That would not be proper. And thirdly, Commissioner Ferland has rotated to the juvenile court bench, so the issue is rather moot. He would not be hearing this hearing.
And irrelevant.
Any other matters in this case.
Okay. Having heard from all the parties and considered the pleadings filed in this case, I'm going to deny the motion to continue.
It's unimportant to me. It's unimportant to me.
And you've provided me with a brief summary. Do you have any recommendations for how to proceed today, sir?
I would like to ask Mr. Quintero the steps he has made to comply with the court's order regarding employment, his participation with One Stop for Arizona at Work, and his job search.
Okay. Let's have the parties sworn in. Could you both please stand and raise your right hand, please?
Excuse me, I'm not interested in that. I require a written response on the record for the motion to continue. I have been lied to before at these meetings. I believe I am being lied to now. I require a written response on the record.
We'll receive a copy of this minute entry denying the motion to continue. A written copy of it in the mail.
Then
In the meantime, please stand and raise your right hand to be sworn.
Nope. Not doing
I'm
that.
not
Do you and each
interested.
of you solemnly swear or affirm to speak the truth, the whole truth, and nothing but the truth, so help you God? Yes.
I'm not interested in these proceedings. I'm only here so this matter could be dismissed with prejudice or write an order I can appeal so I can file lawsuits.
There you go. There you go.
Okay, so I don't have a motion to dismiss in front of me. I had a motion to continue. Right now we're here for a review hearing, and unfortunately that is all I can do. That's all I have the authority to do in this case.
There is
Proceed with the review hearing.
there's an affidavit
So,
of notice and demand with a order for dismissal that was refused by the clerks, who are not allowed to do so, but that should have been sent to you. An affidavit of notice and demand along with an order for dismissal.
Okay, well, today we're here on a motion to continue.
I am here so this matter
at
can be
this point, I've
dismissed.
denied the motion to continue, and we will proceed with the review hearing. If you have other legal actions that are proceeding in this matter, those remedies can be taken up at that time. This is the time set for a review hearing. So please answer the stand and be sworn.
She said, please.
I need a response.
I am not interested in any of that. I'm only here so this matter could be dismissed with prejudice. You can write an order I can appeal, or so I can file my lawsuits.
Are you refusing to answer questions?
I appreciate the questions, but I am not interested in them. I do not consent to these proceedings. I do not consent to being the surety of these proceedings. I demand that the bonds be brought forth so I can see who will indemnify me, because I am a man who was damaged in this matter.
Okay, well, unfortunately, that's not the matter in front of me today. Today, the matter in front of me is a review hearing. And what we are trying to determine is whether or not you have complied with the prior orders regarding obtaining a job and proceeding with providing the court with information regarding your attempts to find work. That is the only issue in front of me today and the only issue I'm able to hear. So at this point, the Attorney General needs to ask you some questions. And you may, once you're sworn in, you may object to the answers or object to the questions that you're asked if you have valid evidentiary objections to them.
Once you submit to the jurisdiction, then you can further incriminate yourself or incriminate yourself even further. That is what she basically said. They're allowed to lie.
So we're here on a review hearing today. This isn't a motion to dismiss or anything else.
I am only here so this matter could be dismissed with prejudice, so you can write an order I can appeal, so I can file my lawsuits.
That's it. That's
I
it.
cannot do anything until you have been sworn in. So can you
I cannot do anything until you have been sworn in. Did you hear that? Let's hear that again.
Matter could be dismissed with prejudice, so you can write an order I can appeal, so I can file my lawsuits.
I cannot do anything until you have been sworn in. So can you please answer the clerk regarding the question she asked?
She said, please.
I appreciate the
3
question. I'm not trying to be disrespectful at all. I'm just not interested. I do not consent.
Okay, and you can make your objections once the questions are asked of you. Right now, will you please just let the clerk swear you in so we can finish the hearing?
4 times she said, please.
I appreciate the question. I am not interested. I do not consent to these proceedings.
Okay. All right, I am going to...
Who is in charge of this hearing right now? Think about it. Who is in charge of this hearing right now? Because from what I heard, that fake judge said please 4 times. If somebody is saying please, they are not in charge. They're asking somebody to do something because they don't have the power to do anything. She said please 4 times. Who is in charge of this hearing right now? Because it's not that fake judge.
Make a record that the petitioner has refused to be sworn and is refusing to answer questions. Sir, and I'm sorry, Mr. Attorney General, I did not catch your name at the beginning.
Full consignment, sitting in for Amanda Earhart.
Thank you. Can you, is there a record you would like to make at this point?
I would have for the record that Mr. Quintero acknowledges the previous court's order.
Acknowledges.
Refusing to be sworn or to provide information to the court as to his compliance contact with either the One Stop or Arizona at Work to obtain guidance regarding employment opportunities and to set an additional review hearing.
Look at the smile on my face. Did you see it? Did you see it right there? Look.
Regarding employment opportunities and to set an additional review hearing.
They have no finding of fact. Sorry. Look at me.
Ms. Hadley, do you have anything you would like to add? Any questions for the court at this time? I'm just curious what another review hearing would do in this circumstance. This is a vexatious litigant who has harassed me for 4 years through the court system. And having another court date for something that he makes clear that he is not going to abide to only burdens me more. I understand that, and it's very frustrating. I'm sure you can appreciate. I can, and I understand that, and unfortunately, the remedies available to the court at this point in time do not include findings for incarceration for contempt based on the pandemic, because of the pandemic.
Liar! Oh my God! Incarceration because of the pandemic. Liar! It's because they couldn't do anything. They had no finding of fact. There was no proof of ability to pay. There was nothing. They couldn't do anything.
At this point, a review hearing is pretty much our only option.
Yeah.
What I am going to do is I will set a review hearing. Give me a second, however. All right, the court finds as follows: that the court has continuing jurisdiction in this matter, that there's a current child support obligation, specifically the child support order that was entered on July 31st, 2017. That child support order is a valid order, and that petitioner does in fact have notice of said child support order. I'm going to reaffirm the prior orders that petitioner shall report any employment that he obtains between now and the next review hearing to the Division of Child Support Services within 2 weeks of obtaining new employment. I'm affirming the prior order that petitioner shall apply for a minimum of 3 jobs per week between now and the review hearing. And affirming the prior order that petitioner shall report to Arizona at Work or Pima County One Stop to obtain any additional guidance or services in connection with his job search. I'm going to set a review hearing for June 8th. Make that June 3rd at 3 p.m. 30 minutes. At which time any additional matters will be addressed. Separate order will be issued with the call-in information for the review hearing. The court further admonishes the petitioner that a failure to appear at any future hearings without good cause may result in the court making a finding of contempt for failure to appear, and a child support arrest warrant may issue.
Oh, there's your threats again. Threaten me. Scare me. Threaten me.
If there's nothing further, I think we can stand adjourned. Thank you, everyone. Thank you.
Just keep it quiet. Well, I spoke with more confidence during this one. As you can see there on the screen, I have my script, and a lot of that was just, the same thing. But that was it. This was shut down. The actual video itself is 17 and 38 seconds, 17 minutes, 38 seconds. Shut down in less than 18 minutes. Stayed in my square. Didn't let them trick me. I was in charge of this hearing. Okay, in case you didn't realize, I was in charge of this hearing. It's irrelevant that they denied the motion because they just pushed everything out anyway to another review hearing a couple months later. It's irrelevant. Okay, so I'm gonna show you the next video how I conquered that as well. But please like, share, and subscribe to the channel. If you need help with coaching or just want to talk to me about what you have going on. I'm not saying I know a lot, but I know enough to get to where I've gotten. And yeah, so please support me. And the channel is I'm So Offended with 3 O's after S. I'm So Offended. And hit me with a donation or a gift if you can, so that way I can continue to do the research and put out these videos, these raw videos straight from the source, the actual court hearings, the actual mouth of the attorney general from the child support office. I get it directly from them. I'll be putting up more videos and also conversations with the clerk of the courts and what it is they do. But anyways, thanks for the support. And also, as always, shout out to Chris from Child Support Made Simple, who helped me with my paperwork and coached me. All right, peace, y'all.